Baldoni as her love interest. He is also the director of the film.
Kind of.
In name, in title.
In name.
When you see the movie, the title says he is the director.
It's not the movie he thought he was directing.
No, and so there's been a lot of talk about why they are really not getting along. When they showed up at the premiere, he refused to take any photos, any group photos with Blake Lively. So there's beef here, but no one attached to the film will say specifically what.
Hi, besties. Is Vanzan the boogeyman? That's what Blake Lively and her attorneys say. And a dust-up that occurred on the docket earlier today and last night has come to a complete and utter thud, with the judge basically denying the motion to compel because they claim that Wayfair was procedurally, they didn't follow the rules of the court by going to the court first for a motion and not having a meet and confer and all of these things. And it didn't stop them from disclosing some details about this lawsuit, the Vanzan sham, that poke a little bit more holes in what's going on and what Blake and her team are doing. Even though they pretend they're not Blake, and they are using a totally different law firm, and they are not agreeing that Blake or Ryan are going to come to this deposition that's apparently supposed to happen on Monday to talk about what happened in Vanzan and how this lawsuit came to pass. I want to just knock out and sort of talk about a couple of the topics of conversation that Kevin Fritz brought to this court. And I know it's already been denied, but I feel like there's some relevant information here. So Kevin Fritz and Wayfair were bringing this conversation to the judge because they want them to testify, and they wanted some sort of like verification that they would be forced to testify to the full period of a relationship between Vanzan and Stephanie Jones. Their claim is that there was like collusion, right, between the two of them, that Vanzan knew exactly what they were doing and they went directly to Stephanie Jones. And so they believe there should have been some like coordinated contact, because why would Stephanie Jones just like willingly hand over everything to some weird shell company in New York through a New York lawsuit? Seems kind of odd, and not even try to object to what the subpoena was seeking. We've not had a lot of information about what exactly they sought in that subpoena. So let me just give you a bit of information. Miss Abel's counterclaims allege that in August 24, just prior to her scheduled departure from Jones Works, the Jones party seized her cellular phone, accessed the contents, and downloaded them. The counterclaim further alleged that Stephanie Jones disclosed at least some of her private communications to the Lively parties no later than August 21st, and continued to access her private text messages thereafter. And at some point transmitted Miss Abel's stolen communications to Miss Lively, her husband, Ryan Reynolds, and Leslie Sloan to harm Miss Abel. Miss Abel also alleges that Miss Lively conspired with the Jones parties to obtain Abel's stolen data under the guise of a legal process. On September 27th, 2024, Miss Lively used her company Vanzan to file a lawsuit in the New York State Supreme Court against Doe defendants, the Vanzan lawsuit. The complaint in the Vanzan lawsuit alleges that the Doe defendants, the identities of whom are unknown to Vanzan, breached unspecified obligations via unspecified oral promises or unspecified written agreements. Days after the Vanzan lawsuit was commenced, Vanzan issued a subpoena therein to the Jones parties demanding production of documents pertaining to the film It Ends With Us, Miss Lively, Mr. Reynolds, and sexual harassment and retaliation in connection with the production of the film, none of which are even remotely referred to in the complaint filed in the Vanzan lawsuit. Jones then handed over the communication to Vanzan. So he has shown the court like what the Vanzan action was. And then the Jones parties then handed over Miss Abel's communications to Vanzan. Subsequently, the Vanzan lawsuit was discontinued in December 24, the same month that she included those communications in her pleadings. So essentially, what he wanted was they were having some fights over privilege and who was going to show up at this deposition. And they did a corporate subpoena, which means someone from the corporation can come as a representative and then they can ask specific questions to the company about this action that was filed. And their argument was that right now we don't know who is going to be the representative. We don't know they don't want to answer any questions before September 27th, 24, and they want to object on other grounds. And I thought the most interesting part of this letter wasn't that they were fighting with Vanzan, because I mean, it feels like it's just a game of they're they're trying to they're like the masked singer, right? And or like they're like the masked man, and they are putting a mask on and they're pretending like they're not really Van Zan, right? And then they're pretending like Van Zan isn't a shell company, in my opinion, by saying that there's all these lawyers that are going to come from this corporation that does nothing to talk about this action, and that the people that seem to be the most connected to this would have been Ryan Reynolds and Blake Lively, and yet they aren't going to show up for this deposition. Instead, it's going to be lawyers. And then they don't want to answer any questions before the 27th of September of 24. So then, interestingly, Van Zan then responded and they said that, well, they're kind of lying about this. And we already agreed we were going to show up and they're just being difficult and blah, blah, blah. And here's what I noticed is they provided a bunch of communications back and forth. And it really just felt like a lot of posturing and gaslighting that was happening from Van Zan. That was my opinion. But I do want to show you what they were said in their response. They're claiming that this letter was to use the court docket to advance an unfounded narrative and generate media coverage around Van Zan, or to manufacture a dispute where none exists. They claim that they told the defendants in writing on multiple occasions before they filed this motion that they were going to comply with this deposition. So they're saying that they should just be denied as moot. Now, the judge didn't deny as moot. Instead, he just said they didn't follow the rules of civil procedure, which was a meet and confer. So it was like dismissed on a technicality, which means that if they continue to argue and it's still not getting resolved, then Kevin can reaffirm and file a new one. With respect to the narrow issues, which is Van Zan's objections regarding the relevant date range of certain topics, they never once raised or conferred with Van Zan on this issue, nor has Van Zan ever refused to provide testimony on any of the topics set forth in the subpoena. Upon receiving their motion, we asked counsel for defendants to withdraw their motion to compel because there is no dispute, therefore nothing to compel. And then they go through their timeline. They say that they will produce a deponent to testify, and they're claiming that this is an attempt to manufacture a dispute where and drag non-party Van Zan into litigation for show, allowing the defendants to reiterate their misleading narrative about Van Zan for the press. They really want to spend time distancing themselves from the fact that this was a sham action, okay? Because they filed that lawsuit, and then the lawsuit has nothing to do with the movie, and yet they're seeking information from Jones Works about a movie, but the lawsuit says nothing about It Ends With Us. It says nothing about Justin Baldoni. It says nothing about sexual harassment. It says nothing about retaliation. It says nothing. And so Wayfair's presentation to the judge was like, this is proof to us that this was brought for improper reasons because they sought discovery that wasn't in line with the claims of the case. And you can't request discovery that doesn't match the case itself. That would be improper. It would be a violation, and knowing full well that they didn't notify anyone and Miss Jones didn't push back, it sort of reiterates to them like, this is done for improper purposes. Because why would Stephanie just hand this over if they didn't know? And so they want the communications between them two so they know why this happened, right? Because what rational business owner would hand over everything with with not so much as an objection? Like, what are you asking for, Van Zan? This has nothing to do with me, right? Their whole claim is they did this to legitimize the data that they already had received, so it wasn't viewed as breach of contract for Stephanie Jones, and so it also was legally obtained by Blake Lively. It is interesting because they objected to the timeline of when questions could be asked, And there's a footnote here, and it says the subpoena contained a time period that began on January 1st, 2022. Any mention of Vanzan in the claims in this Jones litigation relates to Vanzan's involvement in a New York State lawsuit that was filed in September of 24. Thus, Vanzan objected and stated that the appropriate time period was on or about the filing of the lawsuit. It did not, however, refuse to answer questions prior to that date or refuse to provide a corporate designee. As defendants know, had Vanzan sought to limit the scope of the topics, it had to file a motion for a protective order with this court. Instead, Vanzan served an objection and response, met and conferred as appropriate, and confirmed multiple times that it would designate and would testify on the topic. Another footnote says the defendants characterize this as a request to compel testimony about the full period of Vanzan's relationship with plaintiff Stephanie Jones and Jones Works. Defendants used their motion as a vehicle to reiterate their baseless claims, regardless how evidence of their misconduct was obtained from Miss Abel's phone and their media-friendly theory about the underlying Doe litigation in New York court. Defendants suggest without any evidence that there was a prior relationship between Vanzan and Jones Works. Vanzan is preparing a deponent to testify about any alleged relationship Vanzan had with Miss Jones and Jones Works as set forth in the relevant topics. So they're going to deny they had any relationship with Jones, it sounds like. But again, it's like they are saying that this is a way to put out a narrative. And then they also say that the catch-all request was to withdraw all objections to the topic, given the sprawling nature of the defendant's subpoena. Vanzan asserted several standard objections to the topic, including relevance, privilege, work product, burden, time period, and overbreadth. It appears that the real reason made a catch-all demand was to create an appearance of a dispute and meet and confer so that they could file a motion to compel on all of the objections. Defendants had multiple opportunities to raise any concerns about the time period objection specifically, but never did, and simply demanded that all objections, including privileged objection, be withdrawn, is not reasonable or made in good faith. It's interesting, right? They maybe Fritz's communications weren't perfectly reiterated, right? But the point was that they were having a disagreement about the timeline, and then they suddenly tell the court, oh, no, we don't have a disagreement about the timeline. And if we did, we would actually do a protective order, and we're not going to seek a protective order. We'll answer questions. So in a way, it kind of gives him, Fritz, the validation or what he wants, that they're not going to object to questions about that. The judge denied it procedurally because they didn't meet and conferred on this minor technicality. And then he said that they can basically get attorney's fees, which means that he missed a step by meeting and conferring on the timeline, right? If they cannot get to a point where they can agree, then he can come back with a new motion to compel, right? Fritz filed a response and a leave to file request to add more information. And he said that the Wayfair parties were not obligated to wait and hope that at the deposition on September 30th, that Vanzan would withdraw their objection. Upon receiving the formal objections, we asked their counsel to withdraw them, of course, not privileged objections. Vanzan failed to do so. In the early morning of September 25th, 25, we asked the counsel to meet and confer during a morning business hours. Counsel stated it needed to discuss the issue with its clients, Blake and Ryan, and would get back to us later that day or following morning. And then on the 25th, no response was received. Given the looming 30th September deposition, it would be improper to further delay judicial intervention. And even after the motion was filed, they seemingly stated it would withdraw its stated refusal to provide information predating the New York State court lawsuit. We asked the counsel, to prepare a formal stipulation to that effect, which could be so ordered by the court, thereby basis, if one existed, for its refusal to provide information predating the Vanzan lawsuit. No substantive response was received, and Vanzan still has not advised Wayfair parties which of the listed attendings for the deposition, whom all appear to be attorneys, is the corporate designee. To the extent Vanzan is now agreeing to withdraw the time period-based objection, the motion should be granted as unopposed. Well, so even though it was denied, they technically got what they want, right? Because they agreed that they would allow questions about this relationship before the 27th, and that even though, they're still objecting to privilege, that doesn't matter to them because, you can't ask questions on privilege, but they still are unclear about who is going to be the representative because the ones that are named in these emails basically are just attorneys. Now, if Blake and Ryan were actually Van Zan. Blake was at Disney World yesterday, and Ryan was at an event being, Ryan Reynolds. So they were too busy in their real world to deal with such issues of, talking about their company that filed this sham subpoena and filed the sham action. I've talked to attorneys about this, and I've asked them if they think that this lawsuit, the Van Zan one, was filed properly, and they've all said no. I mean, the point here is that if you really believed that your issue and dispute was with Wayfair and it was with the movie, you would have filed the action against the movie and you would have filed the action against Justin and Jen and all these other people, but you didn't. Instead, you used a shell company to avoid the scrutiny. You sued no one so that no one had to be notified of this subpoena, and then you went directly to one person and one person alone that you then use the data that they gave you to file a lawsuit. It's unfair, it's an abusive process, and they're just in my opinion trying to obfuscate that and like minimize it in it, and then it's further minimized by the fact, or it's further complicated by the fact, let's say, that the lawsuit that the Van Zan filed was filed by Manat, and now suddenly they have a brand new attorney representing Van Zan. If it was all under, if it was all above board, what's with all this hiding? What's with all of this, like, trying to cover things up, make it look like it's something that it wasn't? It's very annoying, quite honestly. And, they have been, Blake has been really impossible to deal with on many levels because she has demands that are at times completely unreasonable. And, it puts the Wayfair parties in a position where they are constantly on the defense and having to respond to outlandish claims. And then they're constantly having to defend and, bend to demands. I mean, to give you even more clarity, like she is now asking the judge to compel Wayfair to hand over a bunch of stuff from Signal and say, well, you didn't give us what we wanted, right? And you need to give us this. And well, Steve Sarowitz didn't give us this. And so therefore, I know that there are some things that you didn't give me. And then the response is, we can't give you what we don't have. Like if there's no communications that exist, I can't give you those communications. Or it's like her going to Sourced Intelligence, the PI firm or this investigative company that helped Wayfair and their attorneys with some investigation work for the lawsuit. She falsely accused Sourced Intelligence that they were part of the digital campaign. And the judge literally said to Blake Lively that just because you believe someone did something, you provided zero evidence that they did anything, and you have no proof that they were a part of it. And I have a declaration from the CEO of this company saying that's not true. And your motion to compel is denied because they weren't involved in it. So she has a history of doing subpoenas that are overbroad, that are all over the place, that are trying to get information she shouldn't be able to get. So it's not out of the, scope to assume that Van Zan was the same thing. I feel like it's going to be an uphill battle for Wayfair, and Van Zan's not going to make it easy. And, there was this whole story this week about, someone getting arrested at Taylor Swift's um, house that was supposedly a process server. And then there's all kinds of disputes on whether or not he actually was trying to serve her or she wasn't. And then there's all these articles, and then the local outlets in Kansas are not saying at all that this was tied to someone trying to serve Taylor. But then the national media and the tabloids are saying it is. The locals are saying this guy was arrested. We don't know why he was there. That's it. This is his name. The tabloids are saying they were there to serve Taylor. And then there's a dispute about, well, who's leaking that story? And then are they trying to frame like this is Baldoni's fault? And if he was there to serve her and that he got arrested and he broke the law doing so, that's on him, not on Wayfair. But it does seem like they're trying to plant stories that are unfavorable to Baldoni and apply like he's doing something bad with the subpoena to get headlines. And then behind the scenes, they're literally fighting about Vanzan, right? So it all feels like a deflection from Vanzan. And they continue to try to deny that Vanzan was a legitimate lawsuit. If it was a legitimate lawsuit, why didn't it say anything about sexual harassment? And then why are you subpoenaing Stephanie Jones about Jen Abel? And they really want to know the chain of custody because there's this deposition and the evidence provided could ultimately turn to grounds of Blake's entire basis of her claims and the evidence she provided to the court, all of that getting thrown out if they find that it was done for improper purposes, if the chain of custody wasn't followed, and if, this was done to abuse the process and obtain stuff that they shouldn't have been able to get without notifying someone, that could lead to all of this evidence getting thrown out, which is at the crux of, I think, all of this gaslighting and gamesmanship on the hands of Blake. So they're making things difficult to Wayfair in emails and in communications and playing games. Wayfair is not getting the answers they want, so they filed a motion, almost in a way forcing them to say, okay, we give up, we're going to testify, right? But at the end of the day, we still don't know how much they'll tell. And Blake apparently only answered one question on Vanzan that was one line. So she didn't share anything. So I think that this was a strategic move by Wayfair. I think it got them what they wanted. And I really think that Blake and Ryan are continuing to scramble because this evidence is fragile. It exposes a scheme and it could ultimately blow up in their faces when they finally get Wayfair gets the answers that they want, the evidence that they need to prove that all of this was done with malice and it was done, to abuse the process. And that just opens up the door for litigation that they can sue and other issues that can happen down the way. And it will directly impact Blake's case against Wayfair, which is why they are trying to make this very difficult. It's pretty obvious. That's just my opinion. What are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.